Farmers and ranchers encounter numerous legal issues, often involving farmland in one fashion or another. Two of the biggest areas causing hurdles revolve around eminent domain and financing arrangements. Roger McEowen with the Washburn School of Law joins us now with some guidance in today's Rural Money segment. Thank you so much, Roger, for being with us again. Now, what are some of the main things producers need to keep in mind when it comes to eminent domain?
Well, good to be with you, Tammy. I really think there are two big issues when it comes to eminent domain, and one is to understand that the government has the inherent right to take your property if they want to, but it has to be for a public purpose, and they have to pay you what the Constitution says is just compensation for what they take. And that's really, I think that latter point is where the battle is at for a lot of farmers and ranchers. They want to get fairly compensated for their property rights that they have lost, and so we get into the battle over how we value what's been taken.
Now, what's an example for us?
Well, there's an example of that recently came out of Nebraska. And what you had here was that local government needed to clear some trees from a farmer's property because it was encroaching on intersections in a rural area, and you can't see around the corners. We get into this issue with corn crops and those types of things. But you had trees that were in the so-called right-of-way, but it was still on private property. And so the county came in and said, we'd like to clear some of these trees back, and the landowner gave them permission to do so. But then they cut 164-acre tract, but they strayed outside of the permitted area to cut the trees and cut an additional 67 trees down that affected just shy of 2 acres outside of what the landowner was allowing them to do. And, of course, landowners upset. They want to get compensated for that. And so the issue then is, do you get the replacement value of your trees, or do you get the difference in the land value before the trees were cut down compared to after? And the court said, well, yeah, you're going to get $200. That's the difference pre and post the cutting of the trees. But the replacement cost would have been $150,000. And so it was dramatically different. Landowner only gets $200 out of that one.
Wow, interesting dilemma. Now, what about financing statements?
Yeah, this is a big issue also because farmers and ranchers, you often don't have enough cash on hand to pay for inputs, to pay for machinery, those types of things. And so you sign a security agreement and the creditor files a financing statement. Well, they got to get the debtor's name exactly right. And each state has its standards that it applies so that you can figure out how the public is going to be put on notice that your property is subject to somebody else's security interest. It's been pledged as collateral. And they're going to require almost every state that there has to be an exact match to some standard. Now, in Kansas, for example, you follow the way the name is listed on the driver's license. Any variation from that, such as an extra space or a period or a misplaced letter or a misspelled name, means your security interest is no good. And that happened in a recent Minnesota case where the debtor actually was a business and they changed their name, and the creditor thought that they could just file what's known as a continuation statement down the road when their existing interest lapsed, change the name on that and catch it. And the court said, no, you have to redo a security agreement to make sure it matches the debtor's name, because the whole purpose of the system is to make sure the public, if they were to check the record, would be able to be sure that that particular individual hasn't already pledged that item as collateral to somebody else. So you got to be really careful on this stuff.
Definitely do. That's Roger McEowen with the Washburn School of Law. We appreciate you joining us today.